Welcome back to online classes. Dear students, today I am going to discuss with Indian Penal Code under section 362. 362 explain about abduction. Okay. Here, abduction means whoever by force compels or by any deceitful means induces any person to go from any place is said abduct that person. Okay, this section merely gives a definition of the word abduction which occurs in some of the penal provision which follow. There is no such offense as abduction under the code, but abduction with a certain intent is an offense. Force or fraud is essential. Okay, as per the English law, and there is no separate offense as kidnapping, but under the Indian law, taking a minor out of possession of the guardian too is an abduction. Then again, the Indian law of kidnapping only protects a person of unsound mind and not a mere mental defective, but under section 21 of the Sexual Offences Act 1956, in England, taking a woman who is mentally defective out of possession of her parent or guardian against his will with intent that she shall have unlawful intercourse with men or a particular man is abduction. Two things available of this section, two ingredients. Okay, section 362 requires two ingredients. What are? Number one is forcefully compulsion or inducement by deceitful means, deceiving. Okay. Number two, the object of such compulsion or inducement must be the going of a person from any place. Here the expression deceitful means include a misleading statement. Okay, it is really speaking a matter of intention. The intention of the accused is the basis and gravamen of the charge. The volition, V-O-L-I-T-I-O-N, the volition, the intention and conduct of the woman do not determine the offense. Here the blind, okay, prosecutrix was to go to her school, but the petitioner took her to this secretariat premises, and no evidence is forthcoming that she went there out of her own violation without any inducement by the petitioner. Here the inducement does not necessarily involve any force or compulsion. It simply means persuasion. Okay, but for abduction it must be by deceitful means. There is nothing to show that the prosecutrix had gone of her own volition. Here the place where she had been taken to was not her destination, and any act of the part of the person to lead a woman astray from the path of rectitude is seduction, and if it is followed by the intercourse, it will be seduction for illegal intercourse. The offense of abduction under section 362 of Indian Penal Code involves use of force or deceit to compel or induce any criminal force. Okay, that is, the assault was made to lose his consciousness. Even if the victim would have wished to proceed in any one direction, he would not have been in a position to do so for the reasons of his unconsciousness. Okay, our next part, abduction and kidnapping. Kidnapping is committed only in respect of a minor under 16 years of age if a male, and until 18 years if a female, or a person of unsound mind abduction in respect of a person of any age. Okay. Here in kidnapping, the person kidnapped is removed out of lawful guardianship. A child without a guardian cannot be kidnapped. Abduction as a reference exclusively to the person abducted. Okay. In kidnapping, the minor is simply taken away. The means used may be innocent. In abduction, force, compulsion, or deceitful means are used. In kidnapping, consent of the person taken or enticed is immaterial. In abduction, consent of the person moved, if freely and voluntarily given, condones abduction. The next point, in kidnapping, the intent of the offender is a wholly irrelevant consideration. In abduction, it is the whole important factor. And last point of this kidnapping from guardianship is a substantive offense under this code, that is 362 of IPC. But abduction is an auxiliary act, not punishable by itself, but made criminal only when it is done with the one or other of the intents specified in section 364. Okay. A cases, action of the accused of bringing back his estranged wife to the matrimonial home from the house of PW 6 petitioner witness 6, with whom she was residing after leaving the accused, cannot attract the necessary ingredients of either the offense of kidnapping or abduction. Where the deceased was persuaded by the accused to go with them in the either jeep with a view to settling a dispute which the deceased had with another person, and the deceased thereupon left with them after getting properly dressed. It was held that it could not be said that he was abducted, as there was neither force nor deceit which compelled the deceased to go with the accused person. And another point of view, where the accused was convicted of kidnapping a minor girl, the incident being 5 years old. Okay, and the accused and the victim girl were leading happy married life. Now the sentence of 2 years imprisonment was reduced in the period already undergone. Okay, these are all example cases, and we'll discuss next section of IPC, section 363. Okay, punishment for kidnapping. How many years kidnapping punishment? 7 years. Okay, here the act explain about 363 of IPC explain about punishment for kidnapping, and briefly, whoever kidnaps any person from India or from lawful guardianship shall be punished with imprisonment of either description for a term which may extend it to 7 years and shall also be liable to fine. Okay. And what is the difference between kidnapping, rape and murder based on this section? Here, the accused forcibly took away a girl from the courtyard of the house where she was sleeping with her brother. He raped her in the field and killed her. The accused and co-accused made extrajudicial confession statement. Okay, extrajudicial confessions. The rapist was convicted under section 362 of IPC and 363 of IPC and 376 of IPC and 201 of IPC for the main accused. Okay, and his co-accused, who was standing outside the house when the girl was being forcibly taken away. So in this situation, he was convicted under section 363 of IPC, read with section 34 of IPC and section 366 of IPC. Their conviction was upheld. However, keeping in view that the co-accused took no active part in the offence, so his sentence was reduced to the period already undergone. Now, where accused, the another example of same related case, same related definitions. When accused abducted, sorry, the prosecutrix aged about 9 years. Okay, by tampering her with a bicycle ride and took her to remote place where she was raped and detained by the accused for a whole night. As per the medical evidence, on record showed that prosecutrix had received injuries on her vagina sorry, in addition to the other injuries on her breast, back and forearm. So thus conviction is held proper. Okay, this is one example of case, and another example case. These are all cases only, not example. Okay, this I am giving short method of case law. And another one, an innocent girl of barely 2 years old was kidnapped, only 2 years old, and raped and murdered by the accused. Conviction of the accused purely on the basis of circumstantial evidence under section 363 of IPC and 376 of IPC was upheld, but death sentence awarded under section 302 of IPC was not upheld because the punishment was pronounced under section 304 subclause part 2 of the IPC. As mentioned, to kill the victim could not be attributed to the accused. However, he had knowledge that his act was likely to cause death. Okay, so this section was applied in this case. Okay, student. And another example based on this section 363, prosecutrix willingly going with the accused. Sometimes the kidnapped girl voluntarily, okay, agree with the accused. What happened in this situation? So it appears that on the date of incident, the age of the prosecutrix was near about 17 years 5 months and 17 days. Okay, 17 years 5 months and 17 days, which is below 18 years. But looking to the evidence of the prosecutrix, she left Jar for Mungeli and willingly. Okay, there is no evidence that she was under any threat or coercion or inducement or enticement by the appellants. Here appellant means accused person, because the High Court was already ordered punishment against this accused. The accused was appealed before the appellate court, Supreme Court. Okay, so in this appellants, therefore the conviction of the appellants, that means accused, under section 363 of IPC, read with section 34. Section 34 is common intention, and section 149 of IPC, that 149 of IPC means common object, and under section 366 read with the section 34 of IPC and 149 of IPC. Okay, cannot be sustained. Okay, 366 read with the section 34 and 149 IPC cannot be sustained. Here the allegation was that accused, this is another example of this case, but same topic, prosecutrix willing going with the accused. Here the allegation was the accused threatened the prosecutrix, kidnapped her and had sexual intercourse with her. Age of prosecutrix was about 18 years. Evidence on record indicated that prosecutrix willingly went away with appellant. Appellant means accused person. Okay. There is no evidence of threat here, coercion, inducement. There is no evidence of threat, coercion, inducement established by prosecution. Now the accused acquitted. Okay. And another part of example of under this part, prosecutrix willingly going with the accused. What happened? The accused, where the evidence showing that prosecutrix aged 19 years, accompanied by her elder sister, went with accused voluntarily and did not make any annoyance and performed intercourse with him. Court acquitted the accused. Okay. And another point, another example of this case, prosecutrix remained with the appellant for reasonably long period and had ample opportunity to make complaint to other persons to raise alarm, but she did not do so. The conduct of prosecutrix was showing that she willingly accompanied the appellant. What happened? The prosecutrix willingly going with accused means what happened? Accused released, that's all. Okay. Okay students, that's all 362 of IPC, and we'll discuss another section of this IPC, section 363A. Section 363A of IPC explain about kidnapping or maiming a minor for purpose of begging, taking any begging money some area, because some kidnappers taking any child below age 2 years 5 years, they are utilizing his own profession. Okay. Maiming means wounding. Okay, injury. Here whoever kidnaps any minor or not being the lawful guardian of a minor obtains the custody of the minor in order that such minor may be employed or used for the purpose of begging shall be punished with imprisonment of either description for a term which may extend to 10 years jail and shall also liable to fine. That is section 363A subclause 1. Okay. And 363A subclause 2 explain about whoever maims. Maims means injury or wounds. Whoever injured any minor in order that such minor may be employed or used for the purpose of begging shall be punished with the imprisonment for life and shall also be liable to fine. Okay. And section 363A subclause 3 of IPC, where any person not being the lawful guardian of a minor employs or uses such minor for the purpose of begging, it shall be presumed, unless the contrary is proved, that he kidnapped or otherwise obtained the custody of the minor in order that the minor might be employed or used for the purpose of begging. Okay. And section 363A subclause 4 of the IPC explain about In this section, begging means number 1, soliciting or receiving alms in public place, whether under the pretense of singing a song, or dancing, or fortune telling, performing tricks, or selling articles, or otherwise. And number 2, entering on any private premises for the purpose of soliciting or receiving alms, ALMS, alms. Number 3, exposing or exhibiting with the object of obtaining or extorting alms, any sore, wound, injury, deformity, or disease, whether of himself or any other person or of an animal. And 4th point, using a minor as an exhibit for the purpose of soliciting or receiving alms, ALMS, alms. And B, minor means under subsection 1, in the case of a male, a person under 16 years of the age, and in the case of a female, a person under 18 years of age. Okay, so in this section was inserted Act L2 of 1959. Okay, L2 of 1959. The statement of objects and reason is stated to put down effectively the evil of kidnapping of children for exploiting them for begging. The provision existing in the Indian Penal Code are not quite adequate. There is also no special provision for deterrent punishment for the greater evil of maiming of children so as to make them objects pity. And this section makes kidnapping or obtaining custody of a minor and the maiming of a minor for employing him for begging specific offences and provides for deterrent punishment. Okay students, I am closing this session and we'll meet you again next online classes and another section. Okay, take care, read with properly, study well, wish you all the best. Bye.